First of all, I would like to thank the Portuguese Competition Authority, Autoridade da Concorrência, for inviting me to moderate this very timely panel, Effective Competition as a Catalyst for a More Inclusive and Social Europe. Let me briefly introduce my fellow panelists, although they are very well known to all of you. Isabelle de Silva, President of the Autorité de la Concurrence since her appointment in 2016. She previously served as President of the 6th Chamber of the Conseil d'État, which she had joined in 1994 after graduating from Sorbonne University, HEC Paris Business School, and the École Nationale de l'Administration. She was a member of the board of the Autorité de la Concurrence from 2014 to 2016. Now my fellow panelists that are going to be joining online. Eric Posner is Kirkland and Ellis Distinguished Service Professor of Law in University of Chicago. His research interests include financial regulation, international law, and constitutional law, among many other things. Manuel Leitão Marques is a professor of the Faculty of Economics of the University of Coimbra and permanent researcher at the Center for Social Studies. She has led and participated in several research projects on economic law, competition law, and sociology of law and state administration, both at national and international level. She is now an MP at the European Parliament. Richard Whish is Emeritus Professor of Law at King's College in London. In 2014, he was appointed QC honoris causa. He was a non-executive director of the Office of Fair Trading in the UK from 2003 to 2009, and a non-executive director of the Singapore Energy Markets Authority from 2005 to 2011. He's the author, with David Bailey, of a very well-known book, Competition Law, now in the 9th edition, and the author of many other books, articles, case notes, and books reviews on various aspects of international competition law and policy. Having introduced my colleagues, I would like now to ask the public online and those that are here through their app to answer the question that will appear on your screen, which we will ask both at the start and at the end of the panel to see if your perception of the interplay between labor markets and competition policy has changed, has evolved or not. The question is the following. If you can please project it in the screen, and I will be reading it. And I have to know that there was a little error in the drafting. Now, must labor aspects, not markets, sorry for this, must labor aspects be taken into account as a parameter of competition? Yes, especially in mergers and the application of Articles 101 and 102 of the Treaty of the Function of the European Union to determine the undertaking's anti-competitive harm. No, employment must only be acknowledged as a social consideration and should not be regarded in antitrust. C, yes, but excluding SMEs collective bargaining from Article 101 of the treaty, and also excluding targeted regulatory proposal on the protection of the self-employed. D, yes, through a harsh application of competition law on collective bargaining, mergers and self-regulated professions, irrespective of the circumstances of the undertakings involved. Now, I know that the questions are a little bit complicated, but that is because we've tried to cover so many aspects of the labor issues in competition law. So whilst you are voting, I would like to remind the public that the Q&A functionality is available so that you can address your questions, and hopefully we will have time at the end to answer them. Now, it seems that we have a yes for more or less half of the audience. Okay, I think the results, although varying, are getting stabilized more or less. And we have a majority of voters saying yes, we have to take labor aspects in mergers and in the application of Articles 101 and 122 to determine the undertaking's competitive harm. Let's see if during the panel the answers to this question evolved. Now, competition authorities, as you know, are facing challenges due to the holistic view that is now being introduced in antitrust analysis. It is very much on fashion, such as consideration in digital platforms and ecosystems of private privacy aspects. Also, inequalities in social use of different services, and also the Green Deal that we've been discussing so intensely at the European level. Now, are these elements going to change the traditional view and the parameters that were traditionally analyzing competition, such as dynamics of prices and innovation? In this panel, what we will try to address is how these labor elements have to be addressed in our current antitrust framework. Several changes have been put forward, not only in the European Commission sphere, but also from public consultations that the European Commission has done, national competition authorities, and also from the enforcement side as well. So now we should start by the very basics. Let's start by asking, should authorities, academics, and politicians take into account employment and jobs as an additional parameter of competition in their analysis? And I would like to address first the question to be answered by Eric Posner, who can give us an overview of the recent economic literature, how the US position is, and well, what he believes is the right approach to, for example, independent contractors such as the Uber drivers. Eric, the floor is yours.
Thank you very much, and thank you for having me here to talk to you. I wish I were in Lisbon in person, but this is the next best possibility. Adam Smith, more than 200 years ago, recognized that firms could exercise market power not only in suppressing raising prices for consumers, but also by suppressing wages for workers. And he actually, in The Wealth of Nations, said that it's actually very common for employers to do that. Later, when antitrust law was introduced in the United States in the late 19th century, there was no real discussion about the difference between firms that use their market power to raise prices and firms using their market power to suppress wages. But for complex reasons, in the United States, antitrust law more or less forgot about about workers. There have been very few cases involving workers over the last century in the United States. But this has begun to change just over the last 10 to 15 years. And part of the change is the result of recent developments and discoveries in the economic literature. So if you go back, 20 years or so, labor economists and other economists tended to assume that labor markets were competitive. And I think the picture that they had in their mind was a big city where there would be lots of employers who would compete to hire workers, as a result of which workers would be paid the competitive wage. But in the last 5 years, economists in the United States and in Europe, using new data sets that have been made available, have discovered that, in fact, labor markets are often not competitive at all. They're often quite concentrated. And the economics and the empirical literature are quite complicated, but the simple result of a lot of this work is that if you look around in the United States and Europe, in fact, many labor markets are highly concentrated. This is especially true in rural areas and small towns, suburbs, but even in the big cities, there's some types of occupations or jobs where there are relatively few employers competing for workers. Now, as a matter of economic theory, if only a handful of employers compete for workers in a particular job market, you would expect wages to be suppressed below the competitive rate, or what economists call the marginal revenue product of the worker, basically the amount of value that the worker contributes to the firm. And the empirical work suggests that this is in fact true. Where labor markets are concentrated, wages are lower than they would be otherwise. Now, this is a problem in several ways. Of course, it's unfair to workers who are being paid less than their contribution to output, but it's also bad in a more general economic sense. If workers are being paid less than their marginal revenue product, many of them will stay out of the workforce, as a result of which there'll be less output and growth, and the economy will do less well than it would otherwise. So this is a serious problem, and the economic work has received a great deal of attention, both in the public domain and among government. And both the federal government and many states governments are taking seriously now the problem of labor market monopsony or uncompetitive labor markets. This is regarded as an antitrust or competition law problem in the United States. And in fact, the Justice Department has announced recently 2 criminal indictments of executives at firms that engaged in anti-competitive labor market behavior. The United States government has also brought a number of civil claims against employers who've engaged in anti-competitive labor market behavior, and there are an increasing number of private cases brought against employers for engaging in anti-competitive behavior. So that's roughly the background in the United States. And I think at this point I should turn it over to the next speaker.
Thank you very much, Eric. Let's go now. Richard, can you please give us your review from this time from an EU perspective?
Certainly, thank you, Cani. And you said earlier that we start with the basics, and I think that is the right thing to do. And when I think of the question of competition law and employment markets, I begin with the reflection as a citizen that the inequality of wealth that we see in the world today is absolutely staggering also at any point in my life. And so there's distributional issues, and those issues is of wealth between owners, employers, and their employees. And the literature certainly suggests that the more concentrated markets are, the greater the market power, a greater part of the pie accrues to the benefits of owners and moves away from employees. Now, let's think about this in competition law terms, because there are really some quite complicated technical issues that have to be addressed. Suppose one has between employers and employees. A question that arises is whether to those and might they themselves deprive employees.
Richard, I'm afraid we are losing you. Could I suggest that at least you put your camera off and see whether we have a better line? Well, I think try, please. Try again. No, I'm afraid not. We are going to let's try to give a moment to Richard to see whether the line gets better, and I'm going to give the floor now to Marie Manuel to tackle on social aspects of digital transition. Maria Manuel, what is your view?
Thank you very much, and thank you. And let me first greet for this invitation and all my fellow panel members. Of course, in this time of digital transition, and we discuss in the Parliament different aspects of this digital transition, with so many disruptive innovations affecting the way we produce and perform services, we must pay attention to social impacts. More innovation, and everybody wants more innovation, especially in Europe, and more competition cannot be promoted at the expenses of social rights of being at risk of being rejected by people who is being left behind. And this is a very important problem. It's why we in the Parliament, we discuss both the twin transition, the green and the digital one, but also we pay special attention to the social impacts of these transitions. And there are another aspect related with digital transition, linking labor problems with the competition, that is the platform workers and false independence. Later I'm going to speak about this problem, and unfair competition with other activities, with the same activities performed in a different way. And finally, we are going to have a problem that is competition for specialized or high specialized workers, high digital specialists, and maybe poach agreements can appear or arise in this situation, because we know that we have a lack of people, specialized people, digital people for the ambitious goals we have in digital compass.
Thank you very much, Maria Manuel. Let's try to see whether Richard has recovered the connection. Richard, can you now?
Well, I am here, so the question to you is,
Now,
can you hear me?
We can now hear you. Please go ahead.
There's no difference at my end than there was earlier. But anyway, I will have another go. And what I was saying was that there is an issue of inequality of wealth, and it does seem that power has moved to employers and away from employees. But we then get into technical questions, which is, suppose you have collective bargaining between managerial organizations and trades unions, may those agreements be subject to competition law? Because if so, that could deprive employees even of the right to be represented by trades unions. Well, of course, the Court of Justice addressed that in Albany International in 1999, when there was an agreement between employers' organizations and employees' organizations requiring employees to join a particular pension scheme. Question, was that an agreement between undertakings? Was it subject to Article 101? And it's a fascinating judgment, because the Court of Justice said, well, we believe in Europe in a competition policy, but we also believe in a social policy, and there may be circumstances where these two policies are in tension with one another. And sometimes we as a Court of Justice have to decide which of those policies should prevail over the other. And on that occasion, the Court of Justice said, we believe that here, in relation to collective bargaining, that social policy should prevail over competition policy, and that this area of activity should be excluded from Article 101 altogether. So that was the Albany case. But then subsequently, of course, the world changes, and more people, millions of people now provide services to organizations under a contract of services rather than under a contract of employment. And the question then is, are they employees? And if they're not employees, are they undertakings? Because if they're undertakings, then agreements between them as to the price at which they will supply their services will infringe Article 101. And this gets us to, if you like, the Uber problem. Because if Uber drivers are not employees, if they are undertakings, they agree to fix the prices at which drive for Uber, they are parties to a price fixing agreement with a strict compliant object. And so that is the problem. Whether these kind of agreements would be subject to competition law. And of course, the Commission said consultation, it's now published its inception impact assessment, and clearly it does intend to take action. The question is what action, because it's quite a technically complicated question to decide how the problem should be resolved. Can I just ask whether you are hearing me clearer clearly at the moment, or is there still a technical problem?
No, we can't hear you. There was a moment in which there was vibrations, but we could follow you. Yeah.
Okay. I mean, simply to finish the point off, therefore, we've now had the Commission's impact assessment. There is a public consultation. The question is, how should this problem be resolved? Should it be through a block exemption? Should it be resolved by guidance? Do we need a council regulation to deal with the issue? Could it be seen simply as a matter of de minimis? Separately from that, there's the question of which self-employed persons should be given the benefit of any protection. Is it just digital platform workers? Is it workers more generally? Should it be extended to the liberal professions? So there is a range of issues here to be addressed. Simply to finish, I note that very recently the Australian Competition and Consumer Commission, the ACCC, has given a class exemption to collective bargaining, but not just collective bargaining on the part of self-employed persons, but of small businesses generally. And that includes an exemption for practices such as small businesses collectively getting together to buy electricity from large providers of electricity. So there's a sort of a wider remedy there than the Commission seems to be exploring in its consultation. You also get specific legislative reactions, such as in Ireland in 2017, that passed legislation specifically excluding false employed persons from competition law scrutiny.
Thank you very much, Richard. Now let's go to a more concrete question, and this time I will be addressing first to Isabelle. Let's go now to the merger area. According to the research conducted in May 2021 by the European Corporate Governance Institute, restructuring activity after the acquisition, that is after the competition authority has cleared the merger, is very, very large. Targets lose 55.4% in average of their workforce by the end of the second calendar year after the acquisition, and the combined workforce of the merged firms declines by 7% roughly. More than 40% of the employees who leave the merged firm lose some of their human capital by becoming either unemployed or by accepting a lower paid job. Considering this recent research, maybe merger control must be called in to analyze the prospective impact of the acquisition on labor markets and the restructuring activity to be conducted internally within the firm. That would be the question that the academic are asking. So, Isabelle, in your view, what is the role of competition authorities in merger control in the evaluation of synergies derived mostly from layoffs or in merger control in general?
Thank you, Cani, and let me thank once again Margarida and the Competition Authority of Portugal for this invitation to this wonderful competition day. I think that today we hear a lot of demands to merger control to take in public interest or a broader sense of consumer welfare, and this is a good example of a new demand that is being posed to merger control. And I think that the data that you have just given is very interesting to reflect about a broader question that would be, what is the effect of mergers on the worker, on other type of interest? Still, my answer will be that merger control, to me, is not a tool that is done to protect jobs or to protect members of the workforce. Still, I think that there are some subtle intricacies that I would like to develop in how merger control works and its effect on the workforce. First, as a French competition authority, but I think it's the same for the European Commission and other NCAs in Europe, we do not have traditionally in our legal mission the fact that we should protect the worker or the workforce or the wages. We are here to protect competition, to protect the consumer from the ill effects of a merger. And if we were to say that we are using merger control to protect workers, we would be led to prohibit many mergers that have no effect on competition. Because, for example, if you have two companies merging and each has 5 or 10% of market share, and they decide that they want to lay off a lot of workers. Should we prohibit those mergers if they have no effect on consumer? So I think that a first reason for which we should not take this directly into account, that it is not our mission. And also because in many cases, the effect cannot be predicted in a very coherent manner. We know that some mergers are really made so that there are synergies and efficiencies in the final merged entity. But I think that by keeping the focus on how the merger will affect the competitive process on the market, in the end, we are also helping the economy to be more efficient, because maybe in the short run, the merger will result in maybe some redundancies being analyzed by the merging companies and some layoffs. But what I think we believe is that by having a strict merger control, in the end, the economy is more efficient, more productive, and this will create jobs in the end. So I think it's also something to take into account. Maybe if on the short run the merger produces layoffs, it is not always the case globally. And another interesting feature of the French legal framework for merger is that the competition authority only takes into account the effect on competition, but the Minister for the Economy can intervene and, for example, authorize a merger that we wanted to prohibit by taking into account a public interest, and this can be the effect on the employment. And interestingly, we had a first case of this type of intervention by the minister in a case we had in 2019. We wanted to impose some remedies of divestiture for a merging operation that was leading to very high market shares in the canned food industry. And the Minister for the Economy, Bruno Le Maire, decided to intervene and to cancel the injunction that we wanted to impose on the merger by taking into account employment. Still, there has been only one case of that type, so you see that it's really rare and not something very common. Also because if the minister was to intervene when there is an effect on employment, he would intervene in many, many mergers that we look at every year. And maybe a final word about the economic perspective that Eric gave us at the beginning. I think it's also very interesting to see that if you have an effective merger control, it means that you prevent higher concentration in the market. And in the end, this is positive for the workers, because we know that if there is too much concentration, the workers will be in not a very good position to negotiate wages or to have alternative. So I think that even though it is not the objective of merger control, I do think that a very efficient merger control is good also for the job markets. And maybe final word on other tools. We'll come back later on antitrust enforcement, which is really key on protecting the interests of the workers. But I do think that in many cases, by doing advocacy on reform, we can also fight all type of barriers to entry that are very negative for workers in the economy. And I think that's something that is important to have in mind. So to conclude on your question, I don't think that merger control per se is really the tool to say I will protect jobs, but in some cases by, for example, protecting competition on the market, I'm thinking of the DuPont case or Bayer Monsanto, the Commission decided that there should be divestiture to protect innovation, and maybe this type of remedy protected some jobs of research in that case, and in some other case, I'm thinking about a merger case in which we had there was a high concentration on the press, and we decided that the newspapers should keep separate groups of journalists to protect the diversity in the market. In that case, we had a sort of protection for the jobs of journalists, but this was not the direct objective of the merger control. But in some case, you can have a sort of common interest between protecting the market and protecting the workforce directly after the merger.
Thank you very much, Isabelle. Now, Richard Whish, this time I'm calling to you as a non-EU member. Can you provide us with the UK perspective in the matter?
Well, thank you for reminding me of that, Cani. What I would say is I very much associate myself with everything that Isabelle de Silva has just said. I think that competition authorities are there to ensure that competition is not harmed, and we want an effective competitive economy. and so on. So I don't think this is something that should generally be factored into the equation. Our merger legislation is absolutely specific, that the question is whether the merger will lead to a substantial lessening of competition. We have very narrowly defined public interest overrides to that, which at the moment are protection of plurality of the media, public security, and the stability of financial institutions. It would be open to the minister to add another public interest consideration if he or she thought it appropriate to do so, but there's never been any suggestion, as far as I'm aware, that that should happen. I was just going to mention one case a few years ago, which seemed to me to be quite interesting, as between the UK and France. And that was the acquisition by Eurotunnel, or the proposed acquisition by Eurotunnel of SNCF, which owned some ships that were providing maritime services between France and the UK. And that merger was prohibited in the UK because of its harm to competition. I think it may be the case that the French authority was minded to permit it. And I had the sense, but maybe Isabelle de Silva can comment, I had the sense that there was a thought, perhaps in the French government's mind, that it wanted the seamen that worked on the boats in question's jobs to be protected. And I just wondered, I do not know, but I wondered if employment considerations were there in the background on that occasion.
Thank you, Richard. I'm going now to ask Eric Posner for his view on this, although he already addressed some of it at the first question, but more specifically in a merger case. Please go ahead.
Yes, so I hate to do this, but I disagree with Isabelle and Richard. I think it is very important for the competition authority to evaluate the labor market effects of a merger. Now, I want to be very clear about this. I'm not talking about protecting workers in the sense that a competition authority might worry about, the well-being of workers in some, more social sense. I just mean that when two firms merge, the competition authority, as Isabelle mentioned, is concerned about competition. And there are two types of competition in question here. There's product market competition, which we're all familiar with, but there's also labor market competition. So labor markets are supposed to be competitive. We want labor markets to be competitive if we are in the competition authority. That's part of our job. So let me give an example. So imagine in the United States, for example, there are many rural areas where there might be two large employers. Both of them, let's say, are meat processing plants or factories. So currently there are two large meat processing plants, and they compete for labor. They're people who live in the area, and the firms try to hire people, and they bid up wages in the course of doing that. Okay, so there's a competitive market here for labor. It's not a super competitive market. There are only two employers, but it's still pretty competitive, reasonably competitive. Now imagine that the two employers seek to merge. If they merge, then we go from a situation in which we have two employers that compete for workers to a situation in which we have a single employer, a monopsony, and that will reduce the bargaining power of workers and predictably reduce their wages as well. It should also reduce employment because the newly monopsonized employer will reduce wages, which will reduce employment in order to save costs, in order to save labor costs. These costs, by the way, will not be passed on to consumers because the newly merged firm faces whatever product market structure that it had before. So if that's competitive, it will still charge low prices for the meat that it sells, but it'll make a lot of money by suppressing wages. That's a problem for competition, and therefore it's a problem for the competition authority. The solution to that problem is not complicated. It's really just the mirror image of what competition authorities already do when they evaluate mergers for their product market effects. The first step is to ask whether the proposed merger would significantly concentrate a relevant labor market or more than one relevant labor markets. So in the United States, we use the HHI measure. There are other measures you could use. And then if you do believe that, if you do conclude that the merger would substantially increase local labor market concentration, then the employer would be given the opportunity to defend itself by showing that, in fact, because of synergies or gains in efficiency, it will be the workers will become much more productive, as a result of which their wages will go up rather than down. So that can be done, and I think it should be done. And in the United States, I believe that the competition authorities are moving in that direction. So I hope that in Europe, people will also consider that as a possible direction for reform.
Thank you very much, Eric. We are going to now address another topic, and this is the field of self-regulated professions and self-employed workers, and the challenges that they both pose to effective competition in the respective markets. And I will address my question first to Maria Manuel. How can provisions over certain legal professions, for example, the self-regulated professions that we are all of us thinking of, ensure free movement of workers and a strong competitive market? What is the role of the NCAs? I will then ask other members of the panel. What is the role of the NCAs in this matter? Bearing in mind that the EC's consultation on self-employed workers and the challenges set out in front of false or fake self-employment, what is the most suitable approach to face the problems posed by them from an enforcement and regulatory perspective? And last but not least, what is the role to play for trade unions? So the floor is yours, Maria Manuel.
Thank you very much. Let me only do a small remark on the previous point of measures. Only very, very small. It's a problem we discuss a lot here in the Parliament with Commissioner Breton and Vice President Vestager. That is the relation between strategic autonomy. We are discussing a lot about European strategic autonomy and the measures. To tell you that I'm a little bit worried about strategic autonomy must not be seen as a way to promote the creation of European champions centralized only in one or two countries, those that are closer to Brussels institutions, and the drying up competition from SMEs as well as European innovation. As you remember, this was one of the arguments of the European Commission decision to prohibit Siemens' proposed acquisition of Alstom in 2019. And it's possible nowadays to reinforce the capacity of European companies, but through a decentralized approach using digital tools which bring everyone together, largest players, SMEs, and of course all the member states where they are or can be created. So let me move to the problem of self-regulated profession. Nowadays, at least in some European countries, such as Portugal and the other ones, there are regulated professions and regulated economic activities, such as taxi drivers and pharmacists. There are self-regulated professions, such as doctors, lawyers, engineers, notaries, and so on, and also non-regulated professions, majority of the others. So in many cases, this regulation and self-regulation is justified, for example, to guarantee consumer safety and the quality of professionals that perform the service. However, this is not always the case. Sometimes regulation is not justified by concerns over the public good. And this over-regulation will have negative impacts on competition, which can, in some cases, result in suboptimal quality of service provision and higher prices that do not reflect real costs of the service. And so, at European level, these national requirements make it difficult for professionals to work in other countries, creating barriers to the completion of European internal market when it comes to areas such as services. There is no internal market for services, we need to recognize, or there is an internal market with much problems and too much barriers. So, in other words, self-regulated profession bring challenge to competition in different moments, restricting the number of professionals, creating exclusive acts that can only be performed by some professional, and therefore excluding others who would be qualified to do that, or limiting the number of licenses, as it happens with taxis, at least in some countries, I must repeat. What should we do about it? At European level, it would be important to promote the harmonization of standards and mutual recognition of access to self-regulation professions. And at the national level, it would be important to remove non-justified regulation in order to open the market and promote more competition. What I do not think we can expect or even encourage is the replacement of some of these professions, such as taxi drivers, with false self-employment as a way to escape to any regulation. This is something that is already happening to some extent with this example of taxi drivers, that is being replaced in many countries by false self-employment, as Richard refers at the beginning, through digital platforms, not only creating precarious work conditions, which is a problem, but also creating new problems to competition law. And in the impact assessment that the European Commission published when it launched the consultation of employed workers, they highlight the need to ensure the EU competition law allows initiatives to improve the working condition of self-employed or false self-employed through, for example, collective agreements. And this should be done to guarantee, while guaranteeing that consumers continue to benefit from competitive prices and, of course, innovative business models, and consumers like, of course, innovative products and innovative service. Thank you.
Thank you, Maria Manuel. Now let's go to a competition authority to see how you approach this problem. Isabelle, tell us about your current and past experience in the matter.
Yes, thank you, Cani. I would just like to make a short answer to Eric about his proposal that we should take into account the effect on of a monopoly. I think we are not close to that debate, and I think that the debate has been really very rich over the past few years, especially with a number of works by American academics, and it will be interesting to see if the American authorities are going forward in that direction. There are some elements of that already in what we did concerning mergers in clinics, because in that case we took into account the effect that mergers concerning clinics would have on the doctors that work on those different clinics, and we imposed some remedies that seem quite in line with what you have in mind. But so we have to define a market and an impact on the market. So we'll keep on this discussion, which is really interesting for us. So coming back now to the regulated profession, I want to give an example of a legislative reform that took into account the fact that in these professions, the legal notaries or the bailiffs, we had very strong barriers to entry for those professionals, because you cannot become a legal notary in France if the minister doesn't create a place for you to be active in this profession. And in 2015, there was a very wide-ranging reform called the Loi Macron, because the President of the Republic was then Minister for the Economy, and it created a lot of opposition from the legal professions that were concerned. It was the first time we saw notaries demonstrating in the streets against this reform. But then it's interesting to look at what happened 6 years after that. And one of the idea of this legislative reform was to make it easier to set up shop in this legal profession without having to buy an office to be able to exercise your profession. And what was quite innovative was that the competition authority was really implicated in the enforcement of that reform, because every 2 years we have to define how many professionals could arrive in this profession and exercise these legal professions by taking into account a wide range of criteria, the global economy, the necessity for public service, and also what is happening in the different regions of France. Are there sufficient professionals or not? And interestingly enough, after 6 years of this law being applied, we have seen that the legal notaries have not suffered as much as they feared, because they keep on having very good revenues and being very profitable. But we have seen that there have been a huge number of new professionals exercising, so more competition also for the customer. And also that by lowering this barrier to entry, we have had much more women in that profession being able to become notaries or bailiffs. So it's interesting to see that sometimes when you create more facility to exercise your profession and reducing barriers to entry, you also have progress in terms of gender balance, and also at what age you can access that profession, because we have also seen that the professionals are younger than they used to be. So I think that it's a type of reform that is interesting when you think about the structural reform of the workforce and how people can access different professions. And that is something that should be considered even in very regulated profession, like those were the legal professions, but you could think about this same reform for the health profession, for example, that are also very regulated. And I would like also, we have no representative from the American competition authorities to say that they have done very important work, also the FTC, by acting against the barriers to entry in the different states of the US. So I think it's not only something that we must look at in Europe, but also in the US you have this type of reform that is needed to lower barriers to entry.
Thank you, Isabelle. Now, Richard, from your hat as a European law professor, is there anything that we are missing? Is there anything that we are missing in regulated professions and competition? The lessons should have been known by now, isn't it?
Thank you, Cani. If I may, I was also going to offer one sentence in response to Eric, who started by saying, sorry to disagree with Isabelle and Richard, but to be honest, I don't think there's any disagreement. I think there's a difference between saying, on the one hand, should competition authorities intervene to prevent a merger because 1,000 jobs are going to be lost in a deprived part of the country? I think the answer there is no. On the other hand, if one can see a harm to competition in particular markets, including in labour markets, then I think, of course, that's within the scope of a competition authority's jurisdiction. I think the difference is that in the States, that basically they are ahead of us in thinking about those kind of markets, but we will learn, and I'm sure the time will come when it feeds into the mainstream here. On the question of liberal professions, the point I wanted to make is, I find it very interesting that going back decades, the liberal professions have had competition law cases brought against them, and their first line of defense has been to say, we're liberal professions, competition law doesn't apply to us. And I've just written down a list this afternoon of such cases in the past. Customs agents, architects in Belgium, medical specialists, lawyers, accountants in Portugal, might I say, attestation agents, geologists. And this is a resistance that one finds to the application of competition law, invariably unsuccessful. Isabelle was referring to notaries, and I'm just wondering if people are aware of the case that has just gone to the Court of Justice from Lithuania, case C-12821, and it is about notaries. And the first question essentially is, are notaries undertakings for the purposes of Article 101? And then there are a series of other questions, but what it really comes down to in the end, it seems to me, is what about the Waiters Doctrine? It's a very important doctrine, that you can have associations that make rules for the regulation of the profession, but are they anti-competitive rules, or are they rules that are there to pursue some legitimate public interest? And if so, are the rules proportionate and no more restrictive than is necessary for the purpose? So this is a debate that has gone on, as I say, for many decades, and it's now in the Court of Justice yet again.
Thank you very much, Richard. Now let's go to the last question, the final topic that we are going to address, and then we will go to the poll again. Our host, the Autoridade, issued in April this year for public consultation a preliminary version of a paper, Labor Market Agreements and Competition Policy. And the paper describes very well which are the anti-competitive effects that agreements such as non-poaching have in the market, such as the strengthening of employers' bargaining power or the reinforcement of the conditions to sustain collusive behavior. From an enforcement perspective, several agencies have also dealt with this. I know that the French agency, but also the Portuguese authority, have been dealing with this, and there are other agencies dealing with that from an advocacy perspective, such as my own agency. So now, how to address non-poaching agreements and exclusivity agreements as well, if I may, from an antitrust perspective, which is the best way? I will ask first to Richard Whish, then to Isabelle de Silva, and then to Eric Posner. And if you could please stay into the 10 minutes, all of you together, so 3 minutes each, I would be grateful.
Yes, of course, and thank you very much. It's a fascinating question, and there still has not been one of these cases brought by DG Comp. That is to say, where you have an agreement where undertakings agree not to poach on each other's employees. We know that NCAs are doing it around the place, and we know that the Portuguese authority is looking at the activity recently of the Portuguese Professional Football League and the way in which they reacted to players' response to the COVID crisis. The DOJ, of course, in the States has looked at this, and there have been cases. I just look at it from the point of view of principle. If undertakings agree not to poach each other's employees, can this or should be subject to competition law? Well, it seems to me we have to invoke this idea of the parameters of competition. How do undertakings compete with one another? Perhaps by offering lower prices, perhaps by offering better services, perhaps by being more innovative, but in some circumstances, surely by employing the best people. And if I think of competition between Real Madrid, Manchester United, and Inter Milan, I don't think they compete to offer seat prices at the lowest price. They compete to get Ronaldo. It's absolutely obvious. I say this on the day when he's about to play in an hour's time against Hungary. I will be watching. But it seems to me absolutely obvious in some markets. The quality of the employees is the parameter of competition. So I don't see any difficulty in principle with these agreements being subject to competition law.
Thank you, Richard. Isabelle.
Yes, I think that no poaching agreements are really the next big thing in antitrust enforcement. It's true that we have not seen so many cases, but I think that companies should think seriously about maybe looking at leniency, and because we know that those are very common agreements within companies. So I will not hire someone from your company, you will not hire someone from mine. And this is harmful for workers because it creates less alternative for them. For example, if you are working in the car industry and you want to go from Peugeot to Renault, if it is prohibited by a sort of no-poach agreement, you have less opportunity. And we know, I fully agree with Richard, that it is an important parameter of competition. We know, for example, in the digital industry, some resources are very specific, very hard to find in data science. And some companies are even buying startups to have those resources. So you see how crucial that is. So I think that maybe I'm trying to explain why we have not seen more cases in the past. Maybe there was the idea that competition agencies should focus on cartel, on prices, because they were the most harmful. But this doesn't mean that we should not really target this type of agreements on the basis of 101. And we have at least one important case at the French Competition Agency of 2017. It was a big cartel case, and one element of this cartel between the three big flooring companies in France was that they had a so-called gentleman's agreement not to recruit each other's employees. And they even went so far as to instruct headhunters and recruitment agencies not to look at the workforce of the other members of the cartel for recruitments. So we took that into account, and the final fine was quite important, and several hundred million. So I think companies should be aware that we are really going forward to go against this type of conduct. And I think that maybe this is something that they should take into consideration also for the way they go along to recruit the workforce. So I think that it will be interesting to see what happens in Portugal, and if other agencies in Europe take this type of cases, waiting maybe for the European Commission, if they find such a case, to go forward with.
Thank you very much, Isabel. Eric, we know that Silicon Valley had some problems in non-poaching. Can you explain to us how is the situation nowadays?
Sure. So in the United States as well, for a very long time, the competition authorities did not, even think about no poaching agreements. No one talked about them. There are no cases involving them. There are no investigations. So they weren't part of any kind of public discussion. Back in 2010, though, it was discovered that very famous people, including Steve Jobs, for example, the heads of the biggest Silicon Valley firms, Apple, Google, eBay, and others, had entered into a no poaching agreement. The CEOs had informally, that is not in a written agreement, but just in talking to each other, agreed not to call up each other's software engineers and offer them a job. And I want you to think about this. So these are the CEOs, very wealthy people, the head of enormous companies, which have, very good, sophisticated lawyers. And they engaged in, if this had been on the product market side, if they had agreed not to poach each other's customers, that would have been criminal behavior in the United States. They would have been sent to jail. But because this was a no poaching agreement with respect to workers, I guess the US government wasn't quite sure what to do about it. So they brought a civil suit against the companies, and the companies settled. And they were subsequently sued by their employees, and they settled with the employees as well. Now, in the wake of that scandal, a few years later, the US government sent a kind of a notice to companies and to human resource departments telling them that it is illegal and potentially criminal to engage in no poaching agreements. And that was certainly a good thing to do. That was a start. It's possible that these executives didn't even know that they were doing something illegal, or that their lawyers didn't know. More likely their lawyers told them that it was very unlikely they'd be prosecuted, since it never happened again. But now the government goes ahead and tells everybody, you've now been put on notice, no poaching agreements are illegal, don't do it. Nonetheless, people are still engaging in no poaching agreements. There are not a lot of cases, but there are some cases, including a recent criminal indictment. There's a second criminal indictment relating to wage fixing, but it's basically the same thing. And there are an increasing number of civil suits. I think given maybe the lack of very many legal cases, probably the competition authorities have to do more. Maybe there have to be better whistleblower protections. I think this is just a very difficult setting, because obviously these agreements are not public, and so it's very difficult for the competition authority to learn about them. And the employees don't know about them either, right? They just apply for jobs and are rejected. They're very rarely given the explanation that they're rejected because of a no poaching agreement. That said, there's actually a famous case with Duke University, another famous institution. One of the I guess deans told someone from another university who had applied for a job that I can't hire you because of an agreement with your university, and that also led to litigation. So my sense is these agreements are probably pretty common, and that the competition authorities and governments need to do more to, first of all, inform and warn companies, and then to actually bring lawsuits. There's a more common setting, which is the non-competition agreement, where an employer agrees with the worker that the worker will not go and work for a competitor. Those are a bit more complicated. Presumably, the employer has to pay the worker in return for the worker giving up this opportunity for another job. And there are, justifications for this type of arrangement. In the United States, non-compete agreements are subject to regulation under the common law. They're generally allowed if they're not too severe. But I believe that non-competition agreements should also be subject to antitrust enforcement. And the reason is that when a worker agrees to a non-compete, he or she is not taking into account the overall effect of that agreement on the market. And those sorts of agreements can prevent entry from competing employers and have other negative impacts on the market. But this would require more development than at least we currently have it in the United States. But I do think it's a topic that competition authorities should pay more attention to.
Thank you, Eric. We have just 1 minute to repeat the poll. So I would ask, if possible, to put the question again on the screen and ask everybody to vote again and see whether we have changed anybody's mind. So I remember the questions. Must labor aspects be taken into account as a parameter of competition? Yes, especially in mergers and in application of Articles 101 and 102 to determine the undertaking anti-competitive harm. No, employment must only be acknowledged as a social consideration and should not be regarded in antitrust. Yes, but excluding SMEs collective bargaining from Article 101 scope and targeted regulatory proposal on the protection of the self-employed. Or yes, we should, but from a very harsh competition point of view, to collective bargaining, mergers and self-regulated professions, irrespective of the circumstances of the undertakings involved. So now, let's see how the results are. Okay, so I am not sure that we changed lots of mind in a major result, but yeah, we did slightly in the other answers. So I think at least this was very good fun, and I hope that you enjoy as much as I did. Thank you very much to all the members of the panel. Please join me in congratulating them.